Good morning. My name is George Townsend. I'm a workforce development attorney at Maryland Volunteer Lawyer Service, and I'm going to be going over some new information related to cannabis legalization and its effect on criminal record expungement in the state of Maryland. These are going to be reflecting the changes to the law around cannabis possession and specifically how it relates to the expungement of cannabis-related criminal records. So just as a review, cannabis legalization was passed as a referendum in November of 2022 with a large 65% approval margin. This passed a constitutional amendment in the state of Maryland legalizing adult use and possession of recreational cannabis. It also directed the legislature of Maryland to create some rules for the recreational sale and distribution of cannabis products. And it also changed the rules about expungement of criminal records related to cannabis possession charges, as well as cannabis paraphernalia charges in the past. The referendum specifically legalized possession of certain amounts of cannabis products for people age 21 and over. So it authorized possession of up to 1.5 ounces of cannabis plant products, as well as up to 12 grams of concentrated cannabis. And for a mixture of different products, they can contain up to 750 milligrams of THC. It also authorized a person to grow up to 2 cannabis plants on private property, so long as those plants are out of view of the public and out of reach of anyone under 21 years of age. Public use of cannabis products are not legalized, similar to the regulation of alcohol. And there are still some criminal penalties for the depending on the amount possessed. So as I mentioned a few moments ago, it is legal for an adult to possess up to 1.5 ounces of cannabis plant products. But it is still a criminal penalty to possess over 2.5 ounces of the plant or 20 grams of concentrated cannabis or product totaling more than 1,250 milligrams of THC. Now, as you'll notice, there is a bit of a gap there in between 1.5 ounces and 2.5 ounces, where there would be not a criminal penalty, but a civil liability potentially. Same goes for the gap in between the legal amount of concentrated cannabis and the criminal amount of concentrated cannabis, as well as the amounts of THC products in mixtures. Finally, there's some changes to the law related to possession of paraphernalia. Specifically, it is no longer a crime to possess cannabis-related paraphernalia. So what does this mean for expungement? In general, the rules regarding any criminal charges for cannabis possession that did not end in a conviction are going to be the exact same as they were. So this is any case that ends with a dismissal, acquittal, nol prosequi, stet, or probation before judgment. Same rules apply as apply to any other criminal charges, which can be explored in other trainings on the site we found elsewhere in the Maryland Criminal Procedure Code. For convictions, though, there are some changes for convictions related to cannabis crimes. So specifically, because it is no longer a crime to possess cannabis products up to 1.5 ounces, charges for or convictions for possession up to that amount will now fall under the category of acts no longer a crime and can be expunged under that rule. And as is noted here on the slide, likely a strong argument can be made that possession of up to 2.5 ounces it's no longer a crime to possess up to 2.5 ounces. So likely you would be able to expunge any possession up to 2.5 ounces under the category of acts no longer a crime. For possession charges related to some amount of cannabis products larger than the legal amount, that will become eligible for conviction immediately upon completion of the sentence. So there's no wait period. Once the sentence is completed, those convictions can be expunged immediately, so long as it is for CDS possession for cannabis or marijuana specifically. Now, we do often get cases that are possession with intent to distribute. This is a more severe charge than mere possession. In cases of possession with intent to distribute, where the only substance possessed is cannabis, those are going to become eligible for expungement 3 years after completion of the sentence. Typically, possession with intent to distribute is going to be eligible for expungement. Under the current system, that's 15 years after the completion of the sentence. When the Redeem Act goes into effect on October 1st of 2023, it's going to be reduced to 7 years. However, specifically where it's a possession with intent to distribute for cannabis products specifically, that will be reduced, or is currently already reduced, to 3 years after completion of the sentence. It is also worth knowing that as of July 1st of 2023, possession with intent to distribute cannot be charged if a person is arrested with under 2.5 ounces of cannabis and no other evidence of distribution is present. And then a major change in the way that expungements are handled for cannabis offenses is that there will be a change to the unit rule. So the unit rule is a longstanding rule in expungement procedure in Maryland that when there are multiple charges arising out of the same incident, if any one of those charges are not eligible for expungement, then none of the charges in that unit are eligible. This is a longstanding rule. It's caused a lot of issues where a person will be charged with multiple crimes and either convicted of all of them or convicted of some of which would be eligible for expungement, and some of them are not. And because of the unit rule, none of them are eligible for expungement. That is going to change specifically as it relates to cannabis possession violations. So if a person is charged for use or possession of cannabis, that will no longer be considered part of a unit for unit rule analysis in the context of expungement. So specifically, it will allow a person to file an expungement for an individual charge of cannabis possession, even if there are other non-eligible charges within the case. And then one final new rule related to cannabis expungement is that there will be automatic expungement of many simple possession charges within the next year. So the courts are under an obligation on or before July 1st of 2024, the court must expunge all cases that occurred before July 1st, 2023, or where the charged event occurred before July 1st, 2023, where cannabis possession is the only charge. So any person who is charged solely with cannabis possession prior to July 1st of this year, 2023, should have those charges expunged before or on July 1st of 2024. It should be done automatically, don't have to file any documentation. The courts are supposed to be going through their records and expunging all of those cases at some point within the next year. Now, those cases aren't going to show up on Maryland Case Search. That's already a regulation that Maryland Case Search may not show the charges or even refer to the existence of a case where cannabis possession is the only charge for cases disposed of before July 1st, 2023. So they're already not going to be visible on Case Search. They should be entirely expunged from public records by July 1st of 2024. It is worth, if you or a client you're working with knows that they have cannabis possession charges, to go ahead and file, especially if they're going through like a background check for a new job or something like that in the next couple months, just to make sure that's expunged as quickly as possible. But regardless, even if there is no action taken, if cannabis possession is the only charge, it should be expunged by July 1st of next year. And one final thing to note, sentence modification for people who are currently incarcerated for the possession of cannabis, they may file a petition with the court to modify the sentence, and the court shall grant the application and resentence that person to time served. And if that person is not serving a concurrent sentence for some other crime, then they will be released from incarceration. So essentially, if there is anyone currently in jail or prison for a cannabis possession offense, where that's the only charge that they were convicted of, that person should, as soon as possible, petition the court for a modification of sentence to get their sentence reduced and get them out of incarceration. For those who need to take advantage of these new regulations, there is a new form for expungement specifically for cannabis convictions. It is a simplified form. It requires a lot of the same information as old expungement forms, but it only lists 3 sort of options to select for the reason for the expungement. Those are act no longer a crime, possession of cannabis, or possession of cannabis with intent to distribute. So you just select whichever of those 3 choices is relevant to your case, and then file that just as you would any other expungement petition. Those forms can be found online on the Maryland court website. You just run a quick search for Maryland expungement forms, and it has all of those forms available, including the new cannabis expungement form. Thanks so much for your attention. If you have any further questions or want to review some of the resources, we have a lot of great criminal record expungement resources related to cannabis, related to other charges, all available online at mvlslaw.org. Once again, my name is George Townsend. I'm a workforce development attorney at MVLS. Thank you so much for your time and your attention.